Any mention?
May it please your Lordship. Your Lordship, I beg to mention item number 22. I'm praying for 2 weeks' time, your Lordship.
Three weeks.
Have you obliged, Lordship?
Lordship, I beg to mention item number 19, Lordship. This matter come up after 2 weeks, Lordship. 2 weeks, Lordship.
Old matter. What is this matter about?
A claim of compensation.
Claim of compensation, Lordship.
They're claiming for compensation, if I'm not mistaken, your Lordship. The husband met with an accident.
Oh,
Yes, your Lordship.
claim compensation.
Yes, Lordship.
We should, since 23.
Okay, Lordship.
2 weeks.
Much obliged, Lordship. May it please your Lordship, I beg to mention item number 14, your Lordship. I'm praying for 2 weeks' time, your Lordship.
No objections, Lordship.
It's also very old matter.
Yes, your Lordship. The conducting counsel is having personal difficulties, your Lordship.
1 week.
Obliged. Your Lordship, I beg to mention item number 15. I pray for 2 weeks' time, your Lordship. My learned senior counsel is not feeling well, your Lordship.
This is also very old matter. I think I've made it very clear. You can't go on like this. One week and no more. No further adjournment. Otherwise, I'll impose heavy cost on any party who seeks adjournment.
Your Lordship, I beg to mention item number 11, your Lordship. I'm praying for 2 weeks' time, your Lordship. It's a joint request, your Lordship.
Lordship, 11 and 12 connected matters.
11, 12 connected.
Get connected.
2 weeks.
Much obliged. Please, your Lordship. Your Lordship, I beg to mention item number 13, your Lordship. Your Lordship, I'm praying for 1 week time, your
This
Lordship.
is also an old matter.
Yes, your Lordship. 1 week time, your Lordship.
1 week.
Highly obliged, your Lordship.
Please, your Lordship, I beg to mention item number 16. Your Lordship, I'm appearing for respondent number 9. Your Lordship, I pray this matter may come up after 1 week since the conducting counsel is on a medical emergency.
Medical.
Yes, your Lordship.
Lordship, I strongly object, but due to some unavoidable circumstances.
But then you see, old matters, I have made it very clear. Of course, we cannot impose, but then if lawyers are not, the conducting counsel is not available, we should make alternative arrangement.
Yes, your Lordship.
Sickness we can understand, but 2 weeks.
Well, your Lordship.
Much obliged, your Lordship.
Supplementary list, item number 1.
Please, Your Lordship. Lordship, we have not been able to save the caveator, Your Lordship, in the application. We have not been able to save the caveator, Your Lordship, copy. Lordship, I pray that the matter may come up next week to enable me to save a copy on caveator, Your Lordship.
I
Respondent
appear for
5
the
is the
respondent
caveat
number
of
5, Your Lordship.
He's there.
Lordship, one week time.
Otherwise,
Lordship.
also, Your
Next
Lordship,
week.
let notice go and let the matter come after 2-3 weeks for referral.
Lordship, there's interim, Lordship, in this matter. So, Lordship, if matter could come up on next
Without
week, Lordship.
caveat, of course, interim cannot be heard.
Lordship, I'll serve the notice, Your Lordship, that the matter come up on next week.
Mr. Counsel for the petitioner at the outset has submitted that since notice could not be effected upon the caveator, this matter may be taken up after a week. We allow this accordingly.
Did we pause this item number 1?
May I please, Your Lordship? Your Lordship, I would like to raise some objections on the maintainability of this appeal.
Firstly, this is fixed for admission hearing.
Admission.
Yes, Your Here, Your Lordship, the appellants have actually filed a second appeal in the guise of a first appeal. Now, which is arising out of an interlocutory order of the lower appellate court. Now, Your Lordship, the main title suit and the other matters are pending adjudication. A decree has not been passed yet. Now, if we go to the factual background of the case, Your Lordship, the respondent herein, we had filed a title suit for declaration and also 2 missed cases, one under Order 39, Rule 1 and 2, and the other one under Order 40, Rule 1 for appointment of receiver. Thereafter, Your Honour, the learned Assistant District Judge rejected the injunction application, and aggrieved by that order of rejection, we had filed a civil misapplication before the Additional District Judge. Now, Your Lordship, the Additional District Judge had set aside the order of the Assistant District Judge and remanded back the injunction application for fresh consideration. Now, Lordship, aggrieved by that order, they have filed a first appeal, which is actually barred by Section 1042 of the CPC. Your Lordship, the order which of the Additional District Judge is at page 352.
Yes.
If Your Lordship comes to page 354, here it is clear, para number 1, which says, the appellant assailing in the order dated 23/5/2023, passed by the Learned Court of Assistant District Judge Shillong in Miss Case number so-and-so, arising out of title suit number so-and-so, is before this court by way of an appeal under Order 43, Rule 1R, read with Section 151 of the Code. Now, Your Lordship, if we go to the operative part of the order, which is the last page, Your Honor, at page 376, paragraph number 23.
Yes.
The impugn order, in the opinion of this court, has not been elaborately dealt with in accordance with the requirement of the laws of injunction. In view of the discussion above, the appeal succeeds. The impugn order dated so-and-so, passed by the Learned Court of Assistant to District Judge Shillong in so-and-so, arising out of so-and-so, is hereby set aside. Miss Case so-and-so is restored back to the file of the Assistant District Judge Shillong and remanded back for fresh consideration of application in accordance with law on the powers vested under Section 107, 1B of CPC. Now here, Your Honor, the lower appellate court has not refused the injunction, neither granted. It has only remanded back for fresh consideration. Now, Your Lordship, the order, the impugn order dated 23/4/2026, does not finally determine the rights of the parties here. To determine the rights of the parties, Section 2.2 of the CPC, the decree is described, and then Section 214 of the CPC is where the orders are described, which are not in the nature of a decree. Therefore, Your Honor, in my humble submission, the remand for fresh consideration should be characterized as an appellate order and not a decree. Now, Your Lordship, the present appeal is an attempt to appeal against an order which is not appealable, which is barred by Section 104 of CPC. Lordship, if Your Lordship may kindly come to Section 104 of CPC.
Yes.
Your Honor, Section 104 provides a statutory avenue for an appeal against an order under Order 39, Rule 1 and 2. Now, Your Honor, under Section 104, it says appeals from orders from which appeal lies. An appeal shall lie from the following orders, and save as otherwise expressly provided in the body of the code or by law or by any law for the time being enforced from no other orders. Now, Your Lordship, if we come to 1041I, which is in our case, Your Lordship, it says any order made under the rules from which an appeal is expressly allowed by rules. Now here, Your Lordship, the rules are Rule 43(1)R. Now, Your Lordship, may kindly come to Order 43, Rule 1.
Yes.
Appeals from orders. Appeals from order. An appeal shall lie from the following orders under the provisions of Section 104. So it goes back to Section 104. Section 104 gives the power through these rules, which is Rule R. An order under Rule 1 and 2, Rule 2A, Rule 4, or Rule 10 of Order 39. So this is exactly what we did. We appealed under this section, being aggrieved by the injunction order by the trial court. My submission, Your Lordship, the appeal, which was the only avenue, has already been consumed and exhausted by us. We've already appealed that. And by the bar created by 1042, there's no other appeal, there's no further appeal. Now, Your Lordship, if Your Lordship comes to Section 1042, says, no appeal shall lie from any order passed in appeal under this section. It says any order. It may be refusal, it may be grant, or it may also be remanding it back for fresh consideration. Now, the scheme of Section 104, Your Lordship, does not allow repeated appeals. There's a statutory bar and it cannot be appealed twice. There's only one opportunity which has already been exhausted. Now, the appellants have filed this appeal as a first appeal, Your Lordship. A first appeal would not lie here, Your Lordship, because of the statutory bar under Section 104. And they have filed this first appeal under Section 108 and Section 151. Your Lordship, 108 is just the procedure described of how appeals should be followed. And 151 is the inherent power, of course. But then 151 does not give them the power or create a jurisdiction which is expressly barred by CPC. I have relied on some judgments, Your Honor. If required, I may place it.
Lord, before I answer my learned friend, I'll take Your Lordship to the genesis of the case, my Lord. My Lord, why we have come before Your Lordship? My Lord, admittedly, the petitioner and the respondents are siblings by the same blood, my Lord. Now, my Lord, their great-grandfather had left a will, my Lord. That will was subsequently probated, my Lord. After the will was probated, each was given the share, my Lord. Now, they had gone to...
Is your microphone working?
My Lord, they had gone, the will was probated, my Lord. Now, who probated the will, my Lord? The executor of the will was the husband of the respondent, my Lord. Will was probated, my Lord. Each got everyone's share, my Lord. Now, my Lord, after almost 10 years, they came back to the court of the learned assistant district judge and saying that I did not get my share. Now, my Lord, the will had said the litigation around which the property around which the litigation is centered, my Lord, that was supposed to be divided into 5 shares, 1:5 ratio. Now, they had filed an application before the learned assistant district judge claiming, my Lord, that I have a 50% share. Now, that is where the crux of the matter is, my Lord. My Lord, the will has been probated. They have been given 1/5 share, my Lord, the 5th share. Their name is in the lease agreement, my Lord. Now they are claiming 50%, my Lord. Now, by virtue of that will, my Lord, which has been probated, my Lord, they cannot ask or demand for 50% of the share. First part. Second part, my Lord, there is a business entity being run in the city, my Lord. Now, both I and them were given 50% each, my Lord. Now, she waived off her right by entering into a partnership with others. Now, there also again they are claiming 50%, my Lord. Now, these facts were never brought before the court of the learned assistant district judge. In our reply, my Lord, we had stated that we are ready to give you the share which you are entitled to as per the probation of the will. You cannot ask more than that. As far as the business entity is concerned, you have waived off your right by entering into a partnership of 50%. And your 5th share is already lying in the property. Please come and take possession of it. This is the reason, my Lord, the learned assistant district judge did not see a case for them, my Lord. They did not have a case. Their application under Order 39, Rule 1 and 2 was rejected, my Lord. They had gone to the court of the learned additional judge, my Lord, saying that that order was wrong, my Lord. Now, the learned additional judge, my Lord, has remanded back the order. Now, we are here, my Lord, whether the plaint has to be taken into consideration when an order under Order 39, Rule 1 and 2 is to be passed, my Lord. Obviously, they have mentioned in their application saying that we are relying on the averments made in the plaint, my Lord. Now, when the plaint itself is wrong, my Lord, and their application under Order 39 Rule 1 is rejected, my lord, the facts itself are wrong, my lord. Now, once the facts are wrong, my lord, they have first option to amend the plaint, my lord. They have not done so. They have appealed the order. Now, the learned assistant additional judge had stated, my lord, that the procedure was not followed, my lord. Now, the issue here, which is why I am standing before your lordship, is whether the procedure was followed or not. And they are saying my appeal is not maintainable, my lord. We have come before this court because on the face of it, my lord, the order of the learned additional judge is wrong, my lord, by remanding back the matter. The learned additional judge, my lord, did not, despite of calling the lower court records, my lord, did not pursue the averments made in the plaint, my lord. Now, when the plaint itself is wrong, my lord, you are not entitled to something. You cannot demand that from the court, my lord. And that also after a period of 10 years, my lord. My learned friend have stated, my lord, that it is not an appealable order. They had filed a miscellaneous first appeal, my lord, before the learned additional judge, my lord, assailing the impugn order for them which was impugned by the passed by the assistant district judge, my lord. We are challenging, my lord, the order passed by the additional judge. So that is a first appeal for me, my lord. In the event, my lord, if the learned assistant district judge would have passed an order rejecting their miscellaneous appeal, if they would have come before your lordship, that would have been their second appeal, my lord. My lord, I did not appeal the order. That was fine for me. They had gone for an appeal, and that order of the learned assistant district judge was set aside, remanding back the matter for fresh consideration. So we are here, my lord, as a first appeal, my lord, not a second appeal for us. And as far as 108 is concerned, my lord, this is the procedure which prescribes, my lord, how an appeal has to be filed. Now, the crux of the matter is that, my lord, whether they can challenge an order when the plaint itself is erroneous, my lord. Complete, my lord. If I may take your lordship to.
But I think, Mr. Sharma,
My lord.
see, at the outset,
My lord.
see, the contention is raised is only on a technical issue.
Technical issue, my lord.
Whether your petition or your appeal is maintainable,
My lord.
being preferred as a first appeal,
First appeal, my lord.
which according to the respondent is not maintainable.
My lord.
So, without going to the facts
My lord.
of the matter, or rather the merits,
My lord.
this court will first deal with that issue.
Very well, my lord.
Now, if I can understand correctly, it's a question of perception.
Perception.
According to you, since the order passed, the impugn order passed, was not, in a list which is preferred by you.
My lord.
So it would not matter much, since you are the respondent there.
My lord.
It would not matter much whether it's first appeal or not. But now, when you have appeal against that order, to you it becomes a first appeal.
My lord.
So that is the crux of the matter.
My lord.
Whether now it is for this court to, rather for the parties to convince this court as to whether that contention can be sustained or not.
Exactly, my lord.
Of course, you have to support by relevant authorities or not.
My lord.
So basically, at this stage, this court will confine to that.
Well.
And once the decision is made, then whether this appeal can be, would be listed for admission, will come later.
Very well.
If not, then at the threshold it's dismissed. So we'll confine to that.
My lord.
Is that the extent of your submission?
No, my lord, then I may be allowed to come back, my lord, after a week or so. My lord, I'll take instructions again.
Instruction what?
My lord, I need to prepare myself because this is the.
You have already made a submission. He has made a submission.
Let it go.
Okay. You should have said so at the outset then. That's the crux of the matter. So you please, as far as your authorities are concerned,
Shall I please?
you can submit now, or because he wants to reply.
Okay, then we'll.
My lord, I have also have instructions, my lord, right from day one, my lord. Since we are brothers and sisters, we have showed inclination of settling the matter amicably, my lord.
See, that would have been the best option.
You know, it is on record, my lord. It is on record, my lord.
Mr. Poro, what do you think? What do you think about the idea of mediation?
Your Honor, they aren't allowing us to even enter. They keep saying, please come, but they're not even.
See, we're not going to that. See, if parties, even at this point of time, before even going to this matter, if parties are actively considering settlement, amicable settlement for that matter, then matter can be referred for mediation. In fact, once the process of mediation is initiated, so whatever dispute you have, whatever differences you have, can be solved at one go.
My lord.
In fact, whatever which means that it does not, it's not confined only to this appeal, this first appeal. It will also, affect your, your plain or your petition before the court. You do that. I mean,
in fact,
why don't you?
Your Lordship, the question of settlement had already come before, not once, twice, but then it was never fruitful.
No, but why?
No, my lord, my learned friend, I disagree with him completely, my lord. We had proposed, my lord, we can have a sitting. We can have a sitting and we can talk, my lord. Now, the only issue, my lord, the place of sitting was not decided, my lord. That was the only thing.
Oh, you see, Mr. Sharma, once the parties are inclined for mediation, then it will be court mediation.
Yes, my lord.
So a mediator will be appointed. The mediator will, initiate the process. Parties will be called, and that's all.
My lord,
Not question of place of sitting.
No, with all due respect, my lord, she is residing in Mumbai, my lord. This is the reason why they did not agree to come down to Shillong or to any other place, my lord.
No, even then, you if you have anyone holding power of attorney on your state, you can do that, or I don't know how it can be done. It can also be done by BC.
Yes, my lord.
Yeah. It can be done, but nothing. No papers are required.
At least
it's up to the party.
I'll have to seek instruction.
Then you do one thing. You seek instruction. You come back Monday or Tuesday.
A week's time.
It's just a phone call away. Okay, so we'll list it on 7th.
7th, very well.
But before this matter is taken up for hearing, the Land Council for Respondent has raised the issue of maintainability. However, in course of proceedings, on the suggestion made by the court, parties are inclined to go for mediation as far as this dispute is concerned. The Land Council, however, sought for some time to seek specific instruction as far as mediation is concerned. Accordingly, on preamble, list this matter on 7th. You come back, and if you agree, then
they have to agree, my lord. We are ready.
No, both parties.
From both sides, it's asked.
Fine.
Item number 2.
Item number 3.
No, I thought somebody else. My lord, I'm the proxy counsel here, my lord, appearing on behalf of Mr. B.K. Singh. Mr. B.K. Singh had made a call this morning that he couldn't be here, my lord, due to the occasion of Raksha Bandhan. He had to be at home, and that is the reason why, my lord. I'm only instructions, my lord. I did not know about this matter.
Mentioned how you could have asked for.
My lord, I just got a call. I just received a telephonic
No objection. Short date.
My lord, he's saying that he'll be here on the 15th or the 7th of September, my lord.
7th.
7 or 15.
Short date.
Accommodation is sought for on behalf of the counsel for the appellant who is said to be in this post on grounds of personal difficulty. Mr. Letter counsel for the respondent has no objection to the prayer made. Accordingly, this matter is adjourned and as agreed to by the parties, list the same on 15.
7.
Item number 4.
Lordship, I pray for further time to file my paper book.
Mr. Letter counsel for the appellant has sought for some more time to file the paper book. We allow place this matter to 3 weeks.
Item number 5.
Yes.
May it please your lordship. Your lordship, we have an objection to the condonation of delay. If your lordship may list this matter after 1 week.
Have you filed your response?
No, your lordship. We'll file it after 1 week, your lordship.
If you have, then you should have filed at the outset. Why at this point of time you're coming and you cannot come and say at this point of time that we are objecting and then seek, time to file. You could have done that because the petition was served on you. If you have if you don't have, see, Mr. Upadhyay has no objection.
Yes,
So it's not necessary for him to file.
Yes, your lordship. Your lordship will file it after 1 week.
Miss Land Counsel for the respondent number 4 has submitted that on instruction. She is to say that the respondent number 4 objects to the prayer made for condonation of delay. However, it is prayed that some time may be allowed for a proper response to be filed before this court. Accordingly, as prayed for, this matter after 1 week.
Item number 6.
Please, Lordship.
Lordship, this matter can be taken up with any report, my lord. The arguing counsel, Mr. K.P. Barshaji, is next before point number 2.
End of the board.
Item number 10.
This is the matter. This is the matter where there's yes, Mr. Nomri. This is the matter where the execution.
Your Lordship.
Is there.
Your Lordship. What has happened here, Your Lordship, is that the judgment and decree was passed in the year 2020.
Yes.
Thereafter, we filed an execution petition only in the year 2024. Why? Because the decretal amount was not yet paid to us. So we filed an execution. Thereafter, before the execution court, they have made a commitment that they will pay the amount within 10 days. Thereafter, they file an appeal before this court.
But you are not aggrieved by the award.
No, I'm not aggrieved by the judgment and decree.
Because there are two cases.
There are two cases, but the judgments are different because in the other case, no enhancement was granted. In my case, only 35 lakhs has been enhanced. So I filed an execution case for that 35 lakhs, which now, with interest, it has come to around 61 lakhs to 65 lakhs.
Okay.
So on merit also, Your Lordship, they have come for setting aside the judgment and decree. Now, what will be the consequences if the judgment and decree is set aside and a fresh proceedings is called for? Now the construction is already over. The project has already been used by the public. Can everything be redo?
There's no ground for your appeal. You see, the ground for appeal would, I may be wrong, would be confined only to the quantum.
Absolutely.
They see, if the collector has awarded a certain sum, and that sum is being received under protest, you file a reference before the court.
Your Lordship.
And then the court may enhance, may not, whatever the case may be, and that's about it.
Lordship.
Now you come now and say that they are not entitled to the award per se, will not be proper.
At most,
they have not filed for
Your Lordship,
enhancement.
At most is the other appeal which the private party has filed against that the amount was not enhanced. Your Lordship can interfere only to that extent, whether it should be enhanced or not.
Exactly.
But to call for fresh proceedings now, setting aside, does not call for at this stage. Because the project is over, it's already taken over by the government. We have either we paid or not paid. That's
Lordship, my prayer is
it's
very
impossible now. It is impracticable to again go for a fresh proceedings.
Lordship, my prayer is very much limited, Lordship. Lordship, in the decree part, Lordship, which I have argued in my previous round of argument also, judgment and decree is not matching. Solatium is only on the market value. In the decree part, the solatium is included for the building also. So my prayer to that is very much limited, that in building also, in building the solatium cannot be included, because we have to the act is very much clear that solatium, whatever is the solatium may be calculated, it will be on the market value, not on any other thing, not on building, not on plantation. So my only limited prayer I have come before this honorable court. Okay, that judgment and decree, let it not be quashed, but decree has to be amended, because the solatium, the decree is not in accordance with the judgment. If judgment has come up, if in the decree the solatium is there, then that decree cannot be acceptable, Lordship.
because once the Act says that the market value will be, the solatium will be only based on market value, then suppose for example in the decree page number 366, point number 5, the cost of the building plus solatium at the rate of 30%. So it cannot be done, because once the market value is very much for the land, and in the entire evidence nowhere it came up that they have enhancement should be for the market value. So they could not produce any evidence that which shows that the market value of the land has to be increased. So only on the part of the building it cannot be. So I have come with a limited prayer, Lordship. And if I am I am placing my argument whichever I have argued on my previous round of litigation. With regard to the execution, Lordship, I have repeatedly prayed before the trial court that let at least succession certificate be produced, because the Supreme Court has also stated that to claim, because this money is of has to be released by the government, legal heirship or succession certificate to be produced, which they have not produced, and without taking the consent of the department, because I am representing a government department, so to say. So without taking the consent, I have been forced to admit before the court that you pay within 10 days. But whereas Supreme Court's guideline says that at least one affidavit from the department has to come up stating that you pay within the within specific time, or commitment from the department. I have been forced to do the.
How can you say force?
Because the Lordship will.
Is there any concept of being enforced in a judicial proceeding?
Lordship, it was like I have been asked to without.
The judge has forced you.
Lordship, I have been asked to commit.
How can you?
I'm very sorry, Your Lordship. You can't make that kind of submissions.
Lordship, I have
Very
been
unfortunate.
asked to. Lordship, I have been repeatedly asked to. And
it is for you to resist then, and also if an adverse order is passed, at that point of time you could have
absolutely.
Lordship, thereafter only I came before when the execution court did not taken into consideration. That time only I came before this honourable court, Lordship. And since the only
Your Lordship, may I clarify? Also, what is the appeal now? The appeal she has come against judgment decree. I'm totally surprised by the submissions made by my learned sister, I must say, because in the appeal, kindly see the grounds. What was the ground in their appeal, or what has not been enclosed? Now my learned has made what submissions which is beyond the appeal. She's made submission about the solatium. She's making submission about that she's been forced to. Nothing is there in the appeal. 10 days time they have committed that within 10 days time. I'll read that order also, Your Lordship. They say, give us 10 days time, we'll pay the amount. She's making submission now. She's been forced to. I'll read the entire order. We have produced that he has been. The person who had passed away, he's been substituted as a director.
What about the question of heirship?
The entire order is there, Lordship. I'll read. Order dated, I don't know, order dated 29/5/2025. I'll read, Your Lordship. Order.
Just a moment. Yes.
That this court, by judgment and decree dated 11/3/2020, passed in LA case number 108 of 2015, Your Lordship, has decreed instant case in favor of the claimant Sri Raj Kumar Diora, representative of Sri Radha Creation, in respect of a plot of land measuring about 36,000 square feet situated at JS Road, Khanapara, Temarwet, Right Marwet, Williams Mship, Riboy District, Meghalaya, which was acquired by the opposite party 1 for use of the opposite party 2, and the opposite parties have directed to comply with the said judgment, preferably within a period of 1 year. In case the amount is not paid within 1 year, an additional interest of 15% shall accrue to the said awarded amount till final satisfaction of the judgment decree by the opposite parties. That the opposite parties have failed to comply with the judgment and decree dated 11/3/2020 and to satisfy the same till date, hence the instant execution petition. Counsel for the decree holder has also filed an affidavit bring on record the death certificate of Rajkumar Diore and appointment of Sri Rohit Kumar Diore as a director of Sri Radha Creations Private Limited. During the hearing of the execution petition, learned counsel for the claimant submits that the claimant Sri Rajkumar Diore, representative of Sri Radha Creation Private, died on 25/6/2020 after the judgment and decree has been passed by this court. After his death, his son Rohit Kumar Diore, director of Sri Radha, filed petition under Order 21, Rule 11(2) and 13 of CPC on behalf of his father decree holder, praying for execution of judgment decree dated 11/3/2020. Copy of the death certificate of Rajkumar Diore dated late Rajkumar Diore dated 11/8/2020 issued by the Registrar of Births and Death Municipal Corporation, Gurugram, Haryana. Photocopy of next of kin certificate issued by the Office of the Deputy Commissioner, Kamrup Metropolitan District, and a generated online certificate issued by the Ministry of Corporate Affairs showing the name of Sri Rohit Kumar Diore as the director of Sri Radha Creation Private Limited are produced and submitted. Learned counsel for the decree holder further submit that Sri Rohit Kumar Diore has all along appeared as a representative of the company along with his father, late Rajkumar Diore, and also signed the claimant as a claimant in the claim petition and other documents. Learned GP represented the District Collector, OP number 1, and Learned Counsel for Project Director, National Highway Authority of India, admitted they have not preferred any appeal against the judgment decree dated 11/3/2020 passed by this court. Learned counsels for the opposite parties, number 1 and 2, further submit that they have no objection to the execution petition filed by Sri Rohit Kumar Diore, son of late Rajkumar Diore, and director of Sri Radha Creation Private Limited. However, Sri Rohit Kumar Diore should submit his undertaking on that behalf. Further, both counsels agreed that the calculation of the award as submitted by the counsel for the decree holder is correct. They made that admission too, that it is correct, whatever the calculation has been done. Per use record and as per reference under Section 18 of LA Act 1984 as amended, the Collector, Riboy District Nampo, has informed that Sri Rajkumar Diore, landowner, has accepted the award under protest. It is clear that Rajkumar Diore was the representative of Sri Radha Creation Limited, and after his death, his son Rohit Kumar Diore has succeeded the company as its director. That Sri Rohit Kumar Diore has all along appeared as a representative of the company along with his father Rajkumar Diore, and also signed the claim in the claimant petition and other documents. As such, since the opposite parties have admitted that they have not preferred any appeal against the judgment decree dated 11/3/2020, and the decree holder has expressed his satisfaction with the awarded amount and is ready to indemnify the compensated amount in the event it appears in future that he was not supposed to receive the amount. Even we have made an undertaking before the court, Your Lordship, that even if the amount we are not entitled to, we are willing to indemnify that, return it. Learned counsel for the decree holder praised that he is entitled to receive the compensation award along with interest under so and so, Your Lordship. That is the calculation. Number 3, the total amount due to be received by the decree holder claimant, 61,88,299.4. That since both the judgment debtors has no objection to the instant execution filed by the decree holders, this court is inclined to allow the execution petition, and the decree holder is entitled to receive an amount of rupees so and so from the judgment debtors. This court hereby directed the judgment debtors to pay the amount within a period of 15 days and the same to be deposited before this court, to which the same will be handed over to the decree holder on the next date. Copy of the order to supply to all parties concerned for necessary action. Now, Your Lordship, I'll like to place another order which was passed thereafter. This is 16.6.
Is this order on record?
Yes, Lordship. I have one closed.
That is okay.
Page number 488.
Page number 117, Lordship, of the appeal. So now there's another subsequent order to this which has not been enclosed by my learned friend. So I'll just read that order, Lordship. 15 days time was granted, so the matter was fixed again on 16/6/2025. I'll read, Your Lordship. Case record is put up before me as I have been transferred to Riboy District, Nongpor as Special Judicial Officer by the Honorable High Court so-and-so. The case is fixed today for report. Srimati so-and-so, Learned Counsel for OP1, Collector, is represented. Learned Counsel submitted that there is some confusion with regard to the claimant as there are two names that has appeared. One is Sri Rohit Kumar Diore and the other is so-and-so. Srimati so-and-so, Learned Counsel for the OP, number 2, NHI is present and prays for 10 days time. She prayed for 10 days time in order to deposit the amount of rupees so-and-so and so. The Lordship. Sri so-and-so, Learned Counsel for the decree holder, is present via video conferencing. Learned Counsel has submitted that there is no confusion with regards to the name of the complainant. He also submitted that in reply dated 23/4/2025, the decree was passed exclusively in the favor of Rajkumar Diara in his individual capacity. Hence, there is no confusion whatsoever. I have also perused the said reply and agree with the submission made by the Learned Counsel for the decree holder. Moreover, this instant case is the stage of execution. Learned Counsel for OP to deposit the amount on or before 10 days of passing this order. So this was the final order. After this order, Your Lordship, then they preferred a judgment against the appeal against a judgment decree. Now, Your Lordship, we'll go through the grounds in the appeal. There's no grounds on this execution case. There's no grounds on this solution. The only ground they have raised is that the award was not annexed. That, Your Lordship, I'll satisfy, Your Lordship. I'm also ready with my written argument, which my learned friend also has already argued on that point. So my humble submission, even though if that ground is taken, Your Lordship, like I have submitted earlier, that as a consequence that the project is over. Now the question of setting aside the entire judgment and decree and order for fresh acquisition does not even arise anymore, Lordship. It is impracticable. Yes. And these orders has not been challenged till date also, Your Lordship. If my learned friend makes a submission before this court saying they have been forced, so they have a remedy to that. Which in my humble submission, they were not forced. It is recorded, it's a judicial order that they have agreed, Your Lordship. They can't make that kind. It's very unfortunate to make that kind of submission that they were forced.
Lordship, if I may submit, the entire judgment, which entire executions order, even does not spell that we have objected. Lordship, this is our objections during the executions time, what we have objected, Lordship.
But Your Lordship will have to confine what is pleaded before this court. Now, we can't bring material, taking out materials from the pocket.
Lordship, I am not bringing any material, Lordship. This is already on records, Lordship.
It has to be part of the pleadings.
Not on this appeal, Your Lordship. No grounds in this appeal also.
There are, yes, it should be part of the grounds. See, all these, you see, whatever objection you have should be raised at the appropriate forum.
I have raised that.
And if you see, if you have raised not heeded to, then you have your remedy. You can file an appeal against that order. You have not filed.
Otherwise, Your Lordship, this hearing will never conclude. Every new date, new grounds have been raised.
No.
No, Lordship. Today also I am saying that I am relying my argument on my previous arguments.
Previous argument is only on the award attachment.
No, Lordship,
That's
I
all,
have also
Lordship.
challenged the decrees. I have also stated there the decree is not matching with the judgment. I have also raised that in my previous round of previous arguments. So I am relying on my previous argument, Lordship.
Because the Lordship, I'll confine my submission only to the grounds which she has raised before this appeal. That is all. Can you see the grounds, Your Lordship? What are the grounds they have raised?
Have you filed your written argument here?
No, Lordship, I'll file my I'll file my written argument.
Very unfortunate to
Yes, Mr.
raise
Sen,
new
what is-
grounds on every.
As far as you're concerned,
We have nothing much to say. Our main contention lies in the other.
Yes. The only thing is that why this, because it's all, all combined.
I'll give my written submission with all judgments in it, Lordship. I need a copy.
Heard Miss Counsel for the appellant.
And the
Also heard
maintainability one.
Mr. Counsel, you are respondent? You are respondent
Three,
number?
Lordship.
Number? Yes, Mr. Nobri?
In this appeal, we are respondent number 3, Lordship.
1 and 2 is a state.
Yes, number 3, Lordship.
Number 3. Also heard Mr. SN.
Please, what yet?
Respondent number 1 and 2.
2-8.
Hearings being concluded. Parties are at liberty to file their written argument as prayed for. This is matter of 2 weeks. You file your written argument?
Yes.
Lordship, my written arguments. One is on maintainability and one is on merit, along with all judgments.
Give a copy.
We'll serve them a copy.
Item number 17.
Obliged.
This writ come for the state, my lord. I've already concluded my arguments, my lord.
Where the petitioner?
Mr. P. Bhattacharya is on legs for portion number 2. Sure.
He is to advance his argument.
Lordship.
He is to advance his argument, Mr. Bhattacharya.
He's partly heard, I recall, my lord. He's partly heard.
What to do?
We can have it next week, my lord.
Premier by the parties, this is matter of the 1 week.
Obliged, my lord.
Hello. Item number 18.
May I please, Lordship?
This matter has been heard?
My lord has not heard.
Not yet. Please.
May I please, Lordship?
Yes.
My lord, here the petitioner was enrolled in Assam Rifle, my lord, as a rifleman on 17 November 2006, my lord.
Yes.
My lord, thereafter, my lord, concerning his, he was sent on deputation to the NDRF, National Disaster, for 7 years, my lord, on 10th August 2019, my lord. when he was posted, he was on deputation, my lord. He has submitted a written report in Army, my lord. It's roll call report. Whatever the grievances the petitioner has, he can put in the roll call. That's roll call report, my lord. Submitted on 9th August 2002. 9th August 2022, my lord. 9th August 2022, my lord. That is Annexure 1, page 41.
Yes.
My lord. My lord has got. My lord, without disposing that, my lord, without any disposing or redressal of grievances, my lord, the petitioner was awarded verbally. He was sent on to 14 days rigorous imprisonment in custody, my lord. On 14 September 2022, my lord. The wife of the petitioner, my lord, has filed a habeas corpus petition on being not found. But in reply to that, he came to know that he was awarded a 14 days police rigorous imprisonment custody, my lord.
What is the Mr. Jha, what is the background story of that?
Background is, my lord, he has background story is, my lord, he has.
Who is the petitioner? How finally how he was,
Petitioner is himself.
with the punishment.
Punishment was awarded by the.
How he was appointed? What is his? What was his place of posting or function at the relevant point of time before?
My lord, it was. I'll point out, my lord. It was awarded by the commandant, my lord, of the NDRF, where the petitioner was of when he was on deputation, my lord, to NDRF, and it was awarded. The punishment was given by the commandant of NDRF, which we are challenging before this court. He doesn't have any power to award punishment, my lord.
Yes.
No, it is admitted, my lord, by them. No inquiry was, court of inquiry was given, conducted, based on which the respondent commandant came to a logical conclusion that I have made a false allegation, my lord. The allegation against. My lord, the allegation against the petitioner is that making a false and fabricated. That is that my lord can come to.
Where is the allegation?
My lord, page 20 under bracket A of the affidavit in opposition filed by them.
You have not mentioned that in your petition.
My lord, and in the petition it was nothing given, my lord, to me. Simple. And thereafter, I was served with a movement order, repatriated back. So I have filed a statutory appeal, stating for what purpose I have been awarded punishment. They have not disposed of, so I have to come before this court to suffer a 14 days rigorous imprisonment. My lord will come to say that that is already suffered, but that itself is a illegal. If the commandant doesn't have a power, my lord, to award punishment, my lord, that it goes, my lord. That has to be treated as an illegal detention, my lord. My lord. My lord, page 20 is the allegation, my lord.
Which?
Page 20 of the affidavit in opposition filed by the respondent, my lord.
Respondent 126.
My lord. Additional.
Page 20.
My lord.
Yes. Yes.
My lord. My lord, can my lord, 30, para 30 of the affidavit in opposition, where they have themselves has admitted that no court of inquiry was
Yes. So they said court of inquiry is not necessary.
my lord, but without any investigation, my lord. Till date, even what is the investigation, my lord?
Yes.
How they came to a logical conclusion that I have he has made a false allegation, my lord. Against whom I have, my lord, here it is also no one can be a judge of its own cause. I have filed a complaint against the illegality caused by the commandant, my lord, in my 6th point. And they say that he himself has investigated, commandant himself has investigated, my lord. So how he will be the inquiry officer and even the judge, my lord? And he has awarded me the punishment of 14 days.
Yes.
My lord, as far as the competency of the commandant who has awarded me the punishment, my lord, that I have brought on notification, my lord. That is that additional affidavit dated, my lord, 21st, if I take, my lord, 21st November 2022.
Yes.
In extra R2, my lord.
Page
10, my lord.
Page 10.
Page 10.
Offence report.
No, my lord. Offence report is the Annex 1, my lord.
This is page 10.
Annex
Page
R2, my lord.
R2.
Yes, my lord.
Page 11. Yes.
This is the para C, my lord.
Yes. Para C.
My lord. Disciplinary cases of personal intermixed in NDRF. Intermixed, my lord. They are from Assam Rifle and NDRF, they are on. So if it is intermixed, my lord, what the commandant has to do that, my lord? Immediately on noticing any lapse which requires urgent disciplinary action, the concerned unit commander shall conduct the preliminary inquiry. Shall conduct the preliminary inquiry, my lord. That is, but till now, no inquiry report has been before this honorable court. And simultaneously take up a case for posting him out to the person of that headquarter, my lord. Such person shall be immediately transferred to the battalion of original NDRF battalion, where the commandant will take further necessary action. That commandant will take, my lord. He doesn't have any power, my lord. My lord, here, what are the violations that we have pointed out, my lord? No court of inquiry, no hearing of charge. No hearing of charge was done, which is a mandatory for every awarding the punishment, my lord. Violation of my lord, page 2 of the notes which I have given, my lord.
Yes.
Column 4, my lord.
Yes.
These are the sections and rules which the petitioner, the respondent has not followed in letter or spirit. Nothing is on the record, my lord.
Yes.
My lord, Assam Rifle rules.
Yes.
My lord, rule 53.
Yes.
My lord. My lord, summary disposal of charges against the officer, my lord. Subordinate officer or warrant officer. Here, the petitioner was a rifleman, my lord, which comes within the definition of subordinate officer. My lord, before I come to the other rules, my lord, I will take my lords to the annexer R2 of the R2, page 21
Yes, of what?
of affidavit in opposition filed by the respondent, my lord.
Yes.
My lord, there is no signature of the. This is we have challenged no signature of the petitioner here.
No,
My lord,
no signature of the petitioner.
accused where it is no signature of the petitioner, say, my lord. Page 22, my lord. What is the order given by the commandant, my lord? 14 September 2022, my lord. Last column, my lord.
Yes. You have declined to sign.
They say that.
Yes.
My lord, 14 September, to be tried summarily, my lord. My lord has got it, my lord.
Yes.
To be tried summarily, my lord. That is date 14 September, my lord. So when he was tried, on 14 September, you have already put me behind the bar, my lord.
Yes. Yes.
For 14 days. When that trial proceeded, my lord.
Yes. Yes. So,
My lord. My lord can come to additional affidavit, page 9 annexure. Additional affidavit dated 21st November 2022.
yes.
That is offence report.
Page?
Page 9. Annexure R1.
Yes. Yes.
My lord, column 3
Column 3.
of this offence report, my lord.
Yes.
It's written guilty, my lord. If I have pleaded guilty, my lord, then why the requirement of my lord can come to remark column
Yes.
of this offence report only?
Yes. Where's the remark?
9, column number 9, my lord.
Where's column number 9? Oh, yes.
Is there, my lord. In the remark,
Yes, yes.
the accused refused to make any statement, which itself is a contrary, my lord.
Yes.
If I pleaded guilty, then how the statement will be required? So these all the documents is a manufactured by them, just to justify the punishment, my lord, which they have illegally. In one hand, they are saying that he will be tried summarily, my lord, on 14 September, to be tried. And here also, on 14 September, they say that I am guilty of. So it's a clear case of, my lord, firstly, it is no investigation report. Secondly, my lord, no court of inquiry was conducted. My lord, no court of inquiry was conducted, my lord. And it's he cannot be a judge of its own cause, my lord, against whom I have filed an allegation against him. That's, my lord is well aware that quasha judex, my lord. My lord, I am relying on a judgment of Supreme Court, my lord. (2010).
Yes.
निकाला था
2010.
My lord, 2010, volume 2, SSC, page 72. Page 72.
Yes. Para?
My lord, para, my lord, 31, 23, 25. Para 23, 25, 31 to 39, my lord.
Yes. What does it say?
It says, my lord, departmental inquiry, non-supply of the basic foundation of the documents, whatever the inquiry report, that's violation of principle of natural justice, my lord. Cannot. Here it is a clear case, my lord. Nothing was supplied to him. No inquiry report. They themselves has admitted. He himself has investigated. So it's total violation of the principle of natural justice. And if it is violated, my lord, then the punishment which has awarded by the petitioner to the petitioner, that has to be set aside.
Okay. Anything else?
Yes.
Yes, Dr. Masika.
Lord, kindly come to the prayer, my lord. The repetition. page 34.
Yes.
My first prayer is written in the nature of mandamus, declaring the punishment of 14 days RI as illegal confinement and quashing the impugned BRO dated 24 January 23. Thereafter setting aside the same. Second prayer is writ of issue of further direction to the respondent authorities, a compensation amounting to rupees 2 crore each for illegal detention by the respondent to be deducted from the salary of private respondents. The first submission, my lord, is that this punishment was on 14th September 22 and 14 days RI, and there being no stay at that point of time, my lord, and the writ petition was filed in itself in 2023, my lord. So I think the prayer one has become is already undergone. The punishment has been undergone, my lord. And as far as second prayer, my lord, compensation of 2 crore rupees, this is too far-fetched. They have to make out a case for that, my lord. Now, my lord, here you also can see the first objection I am raising is with regard to the territorial jurisdiction of this honorable court, my lord. My lord, this penalty, everything happened in Punjab, my lord. Page 81, 82, lordship kindly see, this is in Lodhowal, NDRF.
Yes. Yes.
So, lordship, from page 29, I'll just point out, my lord. From page 80, my lord, if lordship kindly see. This penalty was imposed by NDRF, my lord, 13th Battalion NDRF, which was in Punjab, Lodhowal Camp, Ludhiana, Punjab, my lord. Page 80, lordship kindly see.
Page 80, yes.
And by NDRF, my lord, not by Assam Rifles. My lord, if I may take a lordship to my affidavit, my lord, the main affidavit we filed. Page 2, my lord.
Page 2.
I'll just read a few paragraphs, my lord, just to clarify the facts.
Yes.
Subpara A, my lord. The petitioner was enrolled in Assam Rifle on 17/11/2006.
Para 2.
Para 2A, my lord, at page 2.
Yes. Please.
But he was enrolled in Assam Rifle on 17/11/2006. And after completion of basic training, he was posted to assistant Assam Rifles on 25/1/2008. The petitioner was posted on deputation to 13th Battalion NDRF, Assam Rifle, and he was SOS from Assam Rifle with effect from 10/8 to 2019. While serving in 13th Battalion NDRF, the petitioner submitted a written complaint on 9/8/22 in which he levelled allegations against the unit officers. On investigation, all the allegations levelled by the petitioner were found baseless and without any supporting evidence, which became an act prejudicial to good orders and discipline of the force. Thus, the Commandant 13th Battalion NDRF gave an order to take disciplinary action against the petitioner for his false allegation and maligning image of his fellow officers. Accordingly, a tentative charge sheet dated 13/9/22 was served to the petitioner under Section 43A of the Assam Rifle Act for making false allegation against a person subject to the Assam Rifles Act, knowing such allegation to be false. Thereafter, hearing of charge under Rule 47 of the Assam Rifles was conducted, wherein petitioner was provided with full opportunity to defend himself in presence of two prosecution witnesses, and the petitioner was awarded 14 days rigorous imprisonment on 14/9/22 by Commandant 13th Battalion NDRF, Assam Rifles. That further, in accordance with the directions, policies, premature repatriation order on disciplinary grounds in respect to the petitioner was issued by 13th Battalion BRF by letter dated so 30/9/22, and by movement order dated so and so, he was returned back to his parent unit, that is 10 Assam Rifles. It is further submitted petitioner is a habitual offender. Thus, he was awarded 14 days rigorous imprisonment and 14 days pay fine under Section 50E of the Assam Rifle Acts 2006 for attempting to obtain for himself a gratification as a motive for procuring the enrollment of a person while he was attached to his headquarters, DGAR, Vigilance Branch from 22/4/11 to 17/8/2011. So, my lord, the brief case, my lord, he was on deputation to NDRF, my lord. All this inquiry and penalty was imposed when he was on deputation to NDRF in Punjab, my lord. 14 days rigorous imprisonment was imposed on him by NDRF, and thereafter, looking at his conduct and the work how he is doing, he was sent back to Assam Rifles, my lord. Now, after he was sent back to Assam Rifle, now he has filed a case here, my lord, before this honorable court. So that's my first submission, my lord, that he was on deputation to NDRF, and all the penalty orders, the entire cause of action arose in Punjab, my lord. So this honorable court will not have jurisdiction, my lord, or territorial jurisdiction to entertain this petition. Grounds. My lord, it page 23 of my affidavit, my lord.
Yes.
This is a letter from 13th Battalion NDRF, my lord, of 30th September 22, while he was repatriated by this letter, my lord.
Yes.
Read this letter, my lord. It is submitted that number G so and so Jaychand Kumar Gopi, petitioner, my lord, of your unit was on deputation with the battalion with effect from 16 March 2020 to 28 September 2022 and prematurely repatriated to your unit on disciplinary grounds on 28 September 22. Wide NDRF letter number so and so. He was verbally warned several times as well as in written also to improve his behavior and attitude, but the individual failed to do so. The individual awarded 14 days rigorous imprisonment in forced custody under Assam Rifle Act 2006 under Section 43 of false allegations on 14 September 22. He was served warning on 14 March 22 for misbehaving with Battalion Havildar Major and on 17 September 22 for absenting himself in pack drill parade while on forced custody. His wife Srimati Pinky Dev had also filed a writ petition number so and so in the Honorable High Court of Punjab and Haryana at Chandigarh against his forced custody, which was dismissed by the High Court on 27 September 22. So, while this at that point of time, my lord, approached Punjab Haryana High Court, my lord, because the cause of action arose there, my lord. In view of the above, individual is found unsuitable for NDRF rescuer duties and has a negative impact on overall discipline of the troops. He is perpetual offender, indisciplined soldier, instigator, makes groupism and spreads superfluous rumors amongst the troops through WhatsApp group and mobile call recordings. It is recommended that individual be kept under strict vigilance and close observation to monitor his activities, and strict disciplinary action be initiated against him for any indisciplined, unlawful activities. Otherwise, individual may affect on the unit of troops and may tarnish the image of unit force. Hence, individual was prematurely repatriated. Copy of movement and order attached.
Yes.
And page 24 is the movement order, my lord, by which he was repatriated from NDRF to page 26 is the Punjab Haryana High Court order, my lord.
Page 26.
26, my lord.
So he had approached who had approached the Punjab?
His wife had approached, my lord, when he was taken into forced custody, my lord.
For that,
The
habeas
court of-
corpus.
So he filed habeas corpus, my lord. Learned additional submits that petitioner is in lawful custody after following the procedure established in law. Given the above submission, present writ petition is disposed of as having been rendered infructuous. So, my lord, in my humble submission, territorial jurisdiction, my lord, the main respondent will be NDRF, my lord. They should approach Punjab Haryana High Court where NDRF is located, my lord. Because Assam Rifles, we only sent him to NDRF on deputation, my lord. And when they sent him back, we received him back.
Yes, Mr. Jai. See, I think the punishment was meted out by NDRF.
My lord.
So have you made them?
And them, I have made them a party, my lord. I have already made them a party.
So, Dr. Musika, you are appearing for them?
Yeah. They have filed, yes, sir, lordship. They have filed a 126 affidavit on behalf of them, my lord.
6 is NDRF.
So you are making submission on behalf of Assam Rifles or NDRF?
Well, NDRF, in fact, we have not received any instruction. Well, we have not filed affidavit also.
126 is who? Who is 126?
This is a mistake, my lord. These are all. 1 is Union of India, 2 is Assam Rifles, my lord. 2, 3 are 4 Assam Rifles, 5 and 6 are NDRF.
NDRF 126.
You find a joint.
The page 2 is a mistake, my lord. But my lord, in any case, even if I represent NDRF also, my lord.
NDRF has to, you have to justify your action. This court would like to know how was the proceeding conducted, leading to the fact that he was finally meted out with the punishment of rigorous imprisonment for 14 days. Was due procedure followed? That has not been spelled out in your affidavit.
The affidavit is only for some rebels, my lord.
You may challenge jurisdiction or maintainability, but you have to also explain your action.
On behalf of NDRF, in that case, I'll have to. In that case, also can you give some time, my lord? Because preliminary objection I raised, my lord, with regard to territorial jurisdiction. I think there's a recorded one of the orders.
It is not in the affidavit, my lord. Nothing is there, my lord.
At the motion stage itself, I raised this objection, my lord. Yes. That they'll have to go to Punjab Haryana High Court.
But you have not. Yes. What he said is we have not raised anything in your affidavit.
But that was the objection raised on the first day, my lord.
It is not in the affidavit, my lord. Nothing. A whisper. That at that point of time, habeas corpus we approached as a habeas corpus, my lord. Nothing on the merit of the.
I skipped the NDRF will not file affidavit. Give me 2 weeks time, my lord. We will file positive. But otherwise, this without even filing an NDRF affidavit, they should go in Punjab and High Court.
In course of hearing of this petition, Dr. M. Musika at TSGI has submitted that through inadvertence counter affidavit, a specific counter affidavit by respondent NDRF has not been filed. It is prayed that some time may be allowed for instructions to be sought for and necessary steps to be taken. On premier, this seems allowed. This is matter to do. But no, Dr. Moses, no adjournment will be allowed. This is an old matter, we have to dispose it.
That is going to be 3 weeks time.
2 weeks.
Item number 20.
That's 3 weeks time. 3 weeks time. Because where the NDRF is there, I don't know also. I'll have to find out.
3 weeks. Yes.
20.
You are in this, yes.
Yes. It's a final hearing, in fact. But the counsel for the petitioner, Mr. Singh, is not here.
Mr. Thakur is there. Earlier he had appeared.
Milord, it's item 20.
Yes, yes. What are you doing?
I am so sorry, Milord. Yes, I am in item 20, Milord. I am seeking 3 weeks adjournment, Milord, today.
Why?
Milord, the reason is due to one petition is, according to my instructions, one case is pending before the Supreme Court also. And second, Milord, I am also not at my office today because of Raksha Bandhan occasion. 2 weeks or 1 week maybe, not 3 weeks.
Is that an excuse?
So, I am sorry, Milord.
Is that a valid excuse? That you are not?
No, no, Milord may consider. One student has approached the Supreme Court. The petition is pending there.
I don't have any.
I'm so sorry for today. I sincerely apologize from my learned senior friend also.
Where are your details then?
Sorry, Milord.
Where's the details of that petition before Supreme Court? And what bearing it will have on these proceedings?
Milord, it is. I received my instructions from the main council. Also, may adjourn for 1 week only.
After 2 weeks,
Mr.
I apologize for my learned senior also, Milord.
Punit Thakur, Learned Counsel, bearing vice. Mr. A.P. Singh, Learned Counsel for the petitioner, has sought for accommodation on grounds of personal difficulty. Dr. M. Musika, Learned TSGI, you are appearing as senior counsel?
Yes,
Learned senior counsel appears for respondents. On premier, this seems allowed. This is matter of the 3 weeks.
I am so grateful. Much obliged.
Item number 21.
Yes.
For that matter, this is the second order of litigation.
My lord, in the earlier round of litigation, my lord, basically, my lord, they are against the order of eviction which was passed by the government, my lord,
Yes.
which is as per the notice dated 13/6/2019. So in the first round of litigation, my lord, they had approached this honorable court, and the order of this honorable court is, my lord, enclosed at page 16 of the writ petition, my lord.
Page 16.
16, my lord. 16 of the writ petition.
16.
My lord, as per the pagination which I have it here, it shows 16 only, my lord. 14, 15, 16, yes.
We are taking up this 4
My lord, the guiding item before this honorable court was, my lord, the first item taken up was 423 of 2019, my lord, Debjani Devi. This is the earlier also we have been, my friends have forwarded their argument on this only, my lord. This is taken as the lead matter, my lord.
423. Page 16 is also not. This is a letter to the DFO.
My lord, synopsis, yes, it is page 16, my lord. See, but my page it is showing the order of this honorable court, my lord. Something wrong. 16, no?
Oh, yes.
Copy of the writ petition.
How come there are. Oh, this is page 18. Yes.
So, initially, my lord, they had approached this honorable court against the order of eviction, my lord.
Yes.
So, this was disposed at the initial stage itself. Now, my lord will kindly, if I take, my lord, to para 4 of the writ petition, my lord. Apologies, of the said order, my lord.
Yes.
It says that after hearing the learned counsel for the parties and perusing the writ petition without expressing any opinion on merits of the controversy and the issues raised in the writ petition, the same is disposed of at this stage by permitting the petitioner to file a detailed and comprehensive representation against Annexure 10, which was the eviction notice, my lord, before respondent number 2 within 15 days. It is however clarified that in case such a representation is filed, respondent number 2 shall pass a speaking order thereof within next 1 month after affording opportunity of hearing to the petitioner, interested party in accordance with law. So thereafter, they filed a representation which is also enclosed in page 18. 18 to, my lord, 18 to 21. So this is the representation, my lord.
Yes.
Now the government,
Yes.
while considering all the facts and circumstances as well as the relevant provisions of law, my lord,
Yeah.
has taken a decision, my lord. Now, if I am allowed to, I will take a little bit time of this honorable court. If I am allowed to take, my lord, to the representation, my lord, apologies, the response, my lord, of the government, the order, rather the order. My lord, if I before that, my lord, just for clarification of this honorable court, if I am allowed to start with the representation itself, what it says, my lord. That is at page 18. So I take, my lord, back to page 18, my lord. With reference to the subject cited above, this is to inform you that my husband, late so-and-so, was allotted a plot of land at Forest Colony, Shillong, covered by so-and-so, that is Patta dated 17/1/1951, issued by your good office after permission being sanctioned by the then government of Assam, along with heritable and transferable rights to the lessee over the said land. Thereafter, on lease being granted, late so-and-so, on an application being made, was granted building permission by the office of the Shillong Municipal Board, Shillong, wide sanction so-and-so dated 24/1951. On such sanction being granted, late so-and-so had made substantial investments and constructed erected building on the said plot of land with due consent and knowledge of the forest department. Since thereafter, late so and so and his family has been under the continuous possession and occupation of the said land without any let or hindrances. I don't know. It says LEL, my doctor. Or hindrances from any quarter. It may be mentioned that the lease in respect of the said plot of land has been extended from time to time by the Forest Department. Now, time to time, that is actually incorrect, my lord. That the late husband of the petitioner, late so and so, during lifetime had made representation dated 6/12/1972 to the forest authorities to transfer the land to Revenue Department in lines with other lands in other places in Shillong, and since the same was under consideration, my husband was advised to apply for extension of the lease wide letter dated 12/4/1973. Pursuant to the said letter dated 12/4/1973, my husband, late Khargeshwar Sharma, wide letter dated 1973 inter alia, requested the department for extension of lease. Thereafter, the department, wide letter dated 18/8/1977, was pleased to extend the terms of lease of the plot of land on fixation of annual rent at rupees so and so, that my husband, late so and so, besides other lessees, have been making representations to the office for renewal of their lease. As such, your good office was pleased to forward the copies of the said representations to the Chief Conservator of Forest, Shillong, wide letter dated 16/10/1987 for necessary actions, but the said representations were greeted with no response. As the letter was not responded to by the department, as such, the late so and so filed a petition dated 7/8/1998 to the office, which was informed to be under consideration with the government for further action, wide letter dated 5/9/1988, and till date the same is pending consideration. That my late husband Sharma so and so expired in 2007 and as such the undersigned being his legally wedded wife and rightful successor stepped into his shoes for all purposes, and after his expiry the undersigned and her legal heirs, as has been in continuous peaceful possession. That is also actually factually incorrect, my lord. Peaceful possession and occupation of the said premise till date. Furthermore, the undersigned, being the legal wife of so and so, wide letter dated 1/9/2007, had requested the conservator of forest in charge Khasi in Jaintia Hills for renewal of lease, wide reply letter dated 5/12/2019. So, my lord, I'll 2019 2007 had requested the conservator, wide letter dated 5/12/2019. The undersigned was directed to submit application through the DFO Shillong, which was accordingly complied with. Now they've referred to clause 17, my lord, of the agreement, stipulates that on expiry of the lease, the lessee shall have the first offer of renewal thereof on such terms and conditions as the government may prescribe for the time being and for ready reference. So they have quoted the whole clause, my lord, clause 17. However, the fact remains, my lord, there was never any renewal carried out, my lord. After the expiry, only one occasion it was extended. Thereafter, it was not extended thereafter. So the fact remains that there is no lease in favor of the petitioner as on date. Now I take, my lord, to the order which is at page 22. This is the finding, my lord.
Yes.
The representation of so and so dated 29/8/2019 praying for extension of lease of plot 9 situated in Short Round Road protected forest has been carefully perused. All the contentions presented on her behalf on 12/9/2019 during the course of personal hearing granted to her have also been carefully considered. Considering both her representations and contention advanced during the course of personal hearing, So, my lord, she was also afforded personal hearing, and then she was duly represented by her attorney holder, Shri Anil Bajaj. The following is ordered. Contention of the applicant in para 1 of the representation that patta has been granted to the then lessee, Shri so and so, is misleading and false. No patta has been granted to the then lessee. Only a lease agreement was executed with him, which by no stretch of imagination is a patta. It may be noted that the lease of lot number 9 at Short Round Forest has not been extended from time to time, as I have also stated before this Honorable Court. The initial lease of the said plot of forest land had expired on 31st December 1969. The lease was renewed thereafter for a period of 19 years by the state government. The applicant had conveniently avoided stating her representation through resorting to suppression that the DFO had already issued notice twice. So earlier also the notices have been issued saying that you kindly vacate the land. Be prior to the expiry of the lease, my lord. Had already issued notices twice to the then Shri Khargeshwar Sharma, wide notice dated 29/7/1987 and 26/5/1988, respectively, for vacating the premise which has been admitted by the petition, admitted in the petition of so and so dated 1/7/1988, enclosed in the current representation of the applicant. It was also admitted therein that the said notices were issued pursuant to the directions of the state government, wide letters dated 12/2/1985 and 29/7/1987 respectively. Then, my lord, next page, I'll just read few relevant, my lord. Next page again, 3. The state government wide memorandum dated 12 February 1985 had ordered for resumption. So, my lord, there is already a clear order of the state government regarding the resumption of the forest land prior to the expiry of the lease. That means it was extended only once, my lord. Initially it was issued once, subsequently it was extended only once, but prior to the expiry of the said lease, there was already an instruction which was circulated by the government in the year 1985. Had order for resumption of forest land allotted on lease to private persons in Short Round Forest, categorically stating that the lease would not be extended anymore. So it's very clear. There is no ambiguity that hereafter it will not be extended. So the question of having any right over the said land does not arise at all. And my lord, the said notification, my lord, was issued pursuant to the, my lord, passing of this act, the Forest Conservation Act, my lord, 1980. Of course, I have not mentioned the list of books. My lord will kindly see this deals with restriction on de-reservation of forest or use of forest land for non-forest purpose. Notwithstanding anything contained in any other law for the time being force, in a state, no state government or other authority shall make, except with prior approval of the central government, any order directing, this is with regard to lease, my lord, that any reserve forest within the meaning of the expression reserve forest in any law for the time being in force in that state or any portion thereof shall cease to be reserved. Number 2, that any forest land or any portion thereof may be used for any non-forest purpose. Then you have that any forest land or any portion thereof may be assigned by way of lease or otherwise to any private person or to any authority, corporation, agency or any other organization not owned, managed or controlled by the government. That any forest land or any portion thereof may be cleared of trees which have grown naturally in that land or portion for the purpose of using it for afforestation. So, my lord, it says that there is a clear restriction. My lord will kindly see section 2, my lord. It's a very short act. Section 2 of the Forest Conservation Act. So, thereafter, my lord, the state has no authority. If anything is to be done, prior sanction of the central government is required, my lord. So, pursuant to, my lord, passing of this act, this particular order was passed by the state government, stating that hereafter no lease will be extended.
Indian Forest Act?
Yes, my lord, the Forest Conservation Act 1980. My lord will, if this is a bare act, my lord, in my page it is page 91, 1991. Whether it's a similar book or not.
This one.
This is an act of 1980, Forest Conservation Act.
Yes. Para?
My lord, I am referring to section 2, my
Section
lord.
2.
Section 2.
Restriction on the...
Yes, restriction on the de-reservation of forest or use of forest land for non-forest purpose. So, if it is a question of forest land, it has to be used for a
This
forest
Indian
purpose.
Forest Conservation Act is 1980.
1980, my lord.
Yes.
So, this section itself barred any state government to extend any lease or anything to any third party without prior approval of the central government.
Yes.
So that is exactly why, my lord, this direction was issued via this memorandum dated 12 February 1985 by the state government, my lord, which says that the forest authorities will resume the land and the lease will not be extended any further. Now, my lord, if I take, my lord, to then the next para, my lord, para 4 of page 23.
Yes.
While it has been constantly claimed that the applicant is the wife and heir of late so and so, no documentary proof of the same has been furnished by her at any time to the state government while staying in the said premise before or after the expiry of the lease period and death of so and so. So it was never produced. In any case, in spite of relation quoted by the applicant with the erstwhile original leaseholder, her occupation and use of the said plot of forest land is grossly illegal since the lease was never transferred in her favor by the state government. Now that's a very important thing, my lord. You have to, if anything is transferable, then first you will have to have the legal right and transferable right with you. Now whether the petitioner has any right, she has no right at all. So in this regard, the applicant may refer to clause 13 of the lease agreement. So we have also referred, my lord, while disposing the representation, it was observed that in this regard the applicant may refer to clause 13 of the lease agreement wherein it is clearly stated that any change in ownership or possession occurred by succession or by transfer to a government servant, the person becoming entitled by such succession or transfer shall within 2 months from the date thereof give notice in writing to the DFO, Khasi and Jayante Hills of such succession or transfer. No such notice has been received from the applicant before the expiry of lease concerning plot number 9 stated to be occupied by her. No such notice has been received even after expiry of lease. In any case, issuance of any notice of change in possession or ownership becomes grossly irrelevant after expiry of the lease on 31st December 1988. So, my lord, as far as this property is concerned, the lease ultimately attained finality in the year, my lord, 1998. It expired on 31st December 1988. That's it. Thereafter, there has been no extension. There has been no order of extension. Then, my lord, I take, my lord, to page 24. I'm just referring to this, so just for clarity, my lord. This is para 8. The applicant may refer to clause 11 of the agreement wherein the lease shall not be sublet, mortgage, or otherwise transferred the holding to any portion or any portion thereof without obtaining the previous sanction of the provincial government or any officer to be nominated by the government for that purpose. Therefore, no tenants could have been entertained without approval of the state government. Neither the original lessee nor the applicant has obtained any permission from the government to offer the current premise on rent. Thus, if the premise have been rented to tenants either by late so and so or by the applicant as stated in the current representation, the same amounts to serious violation of both clause 11 and 12 of the lease agreement. It may be noted that clause 12 prohibits any kind of business in the said premise. Then again clause 10, my lord, which is at para 9, clause 10 of the agreement may be referred, which confers absolute power on the DFO to take possession of the said plot of land after giving a notice of 3 months only. Such notices were issued long earlier to the original lessee in 1987-1988, that is prior to the expiry, my lord. Several years have elapsed, so it's obvious, my lord.
Yes.
Now, my lord, if I take my lord, if I take my lord to para 11, my lord. Para 10 deals with, my lord, the such encroachers are permitted to be dealt for eviction under Meghalaya Forest, ejectment of unauthorized persons from Reserve Forest Rules 1979. These are the rules which will operate, my lord.
Yes.
Then we have the Meghalaya Forest Regulation 1973. So I take my lord's attention to para 11, my lord.
Yes.
After expiry of the lease in 1988, the occupation of the premise neither by late so-and-so nor by the applicant is either valid or legal. The applicant has further indulged in gross illegality by executing a power of attorney in favor of, so this is some kind of a benami transaction, my lord. Executing power of attorney in favor of Srimati Santosh Bajaj without obtaining any approval from the government. She, Anil Bajaj, admitted that power of attorney was executed with Santosh Bajaj, which is a camouflage of for sale. So this is also, this observation is also there in the order itself, my lord. A tall RCC wall around this premise with a huge iron gate has been erected few years ago without any permission from the forest department. It is difficult to imagine that the applicant had the financial means to erect such a huge construction. In all probability, appears to have been done by the applicant's power of attorney holder. So as I have stated, my lord, this is some kind of a benami transaction. Then, my lord, para 12. Further, there is no provision in the lease agreement for executing any power of attorney with any individual by the leaseholder, inasmuch and much less by the applicant. So the current arrangement of execution of power of attorney is utterly illegal. It is more so since it has been done long after expiry of the lease, when the wife of the original leaseholder and the current applicant had no locus. So obviously, my lord, there has to be some locus. I can execute a power of attorney regarding some property, but for that I'll have to have the right, transferable right, ownership rights. Without that, it is useless. Then, my lord, para 13, with reference to clause 17 of the lease agreement, it is stated that the first offer for extension was granted to the leaseholder in 1969, and the occasion for offering extension for the second time does not arise. In any case, after enactment of Forest Conservation Act 1980, so I had what I had already stated, my lord. No extension of lease can be granted without approval of the central government thereof. In fact, clause 17 of the lease agreement, which was signed in 1951, becomes void after enactment of the Forest Conservation Act 1980, which expressly directs that no forest land can be diverted through sale or lease without approval of the central government. So question of extension of lease anyway failed, my lord. Further, when resumption of premises is resorted to, which is exercisable under clause 10 of the lease agreement, clause 17 becomes insignificant and inoperative, and more so in view of Forest Conservation Act 1980. Under the backdrop of the Forest Conservation Act 1980, the state government wide letter dated 19, what I had already submitted earlier, my lord.
Yes.
Government wide letter dated by letter 1985 had directed resumption of all lease plots of lands in the short round forest. So, my lord, this concerns all the lands. In the area of the forest land, yes. So, my lord, thereafter, my lord, I take my lord to para 15, my lord. It refers to the guiding principle, my lord.
Each?
Page 26.
Yes.
Of the said order. In the aforesaid circumstances, several pronouncements of the Honorable Supreme Court on the inviolability of FC Act 1980 and the status of those residing without authority on forest land become relevant and binding on both the public and the forest department officers alike, who are bound to follow them and accept them as the law of the land by virtue of Article 144 of the Constitution. The various pronouncements of the Apex Court on this subject are briefly recapitulated as follows. So you have relied on the T. Godavarman, my lord, versus Union of India 2008, 16 SCC 337. So I've held, page 343, have held as below on the issue of eviction of encroachers over forest land and the compulsory need to evict such encroachers even with force if necessary. So they have quoted para 18, my lord. If I have the permission, I can read it, my lord. Subsequent, only the initial. There can be no manner of doubt that any land which forms part of Tatokola Reserve Forest could not belong to the government. Once the forest was established in the year 1936, all other rights therein came to an end. The moment it's considered as it becomes a forest land, there is no other right. The survey members of the forest are indicated in the plan prepared by the Survey of India, and there is no dispute that survey number 4 forms part of the said forest. It has been contended by anyone that survey 3 was part of the forest land. Therefore, any person who owns land which forms part of survey number 3 as identified by the Survey of India would be entitled to enjoy the same, and that the land did not form a part of the reserve forest. What the Survey of India had to do was really to demarcate the boundary of the reserved forest and to indicate which portion of the land fell in survey number 4 and which portion of the land in that area fell outside the said reserve forest, including survey number 3. In the plan filed, this has been indicated, and according to the said plan, portions of survey number 4 have been shown to be encroached upon. The total area in occupation of the encroachers in the said forest is stated to be more than 611 point so and so acres. It may also be noticed that though in notification of 1936 it was stated that the total area of forest was 2312 acres and 38 guntas, but as per the report of the Survey of India, the survey which was conducted with the help of the latest scientific instrument show that the correct area of the forest was 2269.198 acres. This area of land stands identified in the plan now drawn up by the Survey of India. From the aforesaid, it is quite clear that all encroachers into the Tatoloka forest have to be evicted. It is no doubt true that according to section 64A, a showcase notice has to be issued, but that can only be with view to enable the person to whom notice is issued to show that his land does not fall within the boundaries of the forest as drawn up by the Survey of India. If the land is identified as falling within the Survey of India boundary, then there could be no defense open to persons concerned, and the state would.
Yes, please, sorry.
And the state would be under an obligation and duty to evict encroacher by force if necessary. So here, my lord, this is finding that there is no doubt that this is a part. Now, when, my lord, the allotment, the initial allotment and the subsequent extension is by forest department, can there be a dispute saying it's not a forest land? It cannot be, because who is the authority? The source of the authority, the source of through which you obtain the land, the piece of land, it is the forest department. So therefore, it is amply clear that this land belongs to the forest department. It cannot be, the dispute cannot, there cannot be any dispute with that regard. So, my lord, it is not disputed that the current plot of land, that is plot number 9, is part of short round protected forest. My lord, that I referring to page 27, my lord.
Yes.
After the
Yes.
It is not disputed that the current plot of land, that is plot number 9, is a part of short round protected forest. Therefore, the only option under law is to evict the current occupant as directed by the Apex Court. So, and then we have referred to quoted other judgments as well, my lords. So, I'll not take the trouble of taking lordship through all that. I straightway take my lord to page 31, my lord. Para 16. Para 16, my lord.
Yes.
During the course of personal hearing, it was contended strenuously that the provisions of Forest Conservation Act will not apply to the instant case for extension of lease, since original lease was executed in 1951. In view of the above ruling of the Honorable Supreme Court, the said contentions is without any substance and only to be rejected. In view of the facts and legal position stated in the foregoing paras, it is clear that the applicants, Srimati Debjani Devi and her power of attorney holder, have no right whatsoever on the said plot of land in short round forest. This is PFS. In the protected forest. Yes. Shillong for any kind of occupation, either temporary or permanent, or any kinds of lease or extension thereof. The notice issued by the DFO, white letter number so and so, dated 13 June 2019, is affirmed hereby and upheld, and the representation of the applicant, dated 29/8/2019, addressed to the DFO, is rejected as being bereft of merit and substance. The applicant and her general power of attorney holder are directed to comply with the aforesaid notice by the Divisional Forest Officer, white letter number so and so, dated 13 June 2019, and vacate the premise immediately. So, Lord, the detailed hearing was taken. Now, my Lord will find the observation at page 33 also, where the petition was allowed through the attorney holder, my Lord.
Yes.
Hearing on representation of the representatives of so and so, leaseholder of plot number 9 at Forest Colony Short Noun, Reserve Forest, held on 12 September 2019. Now here it says, I Shri Anil Bajaj representing Srimati so and so was granted personal hearing in the office chamber of so and so in so and so, dated 12/9/2019. In 1951, we made dealing and had a relation with the house owner. This is their statement, my lord. He is a good friend of mine, a family friend of us. The transfer of lease land will be under consideration, but we apply for renewal and we got the renewal up to 1988. In Shillong and in European world also, and anywhere, 99% of the land is under Patta Shillong and European world also. Land Patta is, apologies my lord, I missed the paragraph. In Shillong and in European world also, and anywhere, 99% of the land is under Patta and lease. In 1971, we got the letter to apply for renewal and we got up to 1980. In 1987, we reapply for renewal, but that time we were not given and the case was under consideration. Then in 1988 and 2007, and every time when the letter comes, your case is considered under government. In 2016, but it's not enclosed, my lord. In 2016, the DC office has done survey of the land to find out whether we occupy the land, and we requested to go for renewal of consideration, and after that nothing else happened. The owner leaseholder is old and lady, she cannot come, and she requested us to take the power of attorney to look after the land and everything. My lord will kindly see after that our request as per our case. As you know, Shillong is a small area. Please consider and renew the lease. That is our request. Srimati Debjani Devi is the legal heir. Now it says, I have not purchased the land and I am only the caretaker. We have not taken anything as she cannot come. So these are the, so to say, the observations in the hearing, my lord, and their signatures are there in the next page.
Yes.
So sum and substance, my lord, is that they have approached this honorable court against the order of eviction. So at first round they came, this honorable court said that you file a representation, and they filed a representation. Accordingly, the government considered, taken all things into consideration, including the relevant laws in force, and thereafter decided against them. Subsequently, they have approached this honorable court. Now, in this case, we have filed our affidavit in opposition, my lord, Now, may I take, my lords, to the affidavit in opposition, which are these are very relevant, my lord. If I take, my lord, to Annexure 1, page 17. Of the affidavit in opposition, my lord, which is filed with the government. This is filed sometime in 2019, my lord, 25/11/2019.
Yes, sir. Yes. Yes.
So, my lord, this is the notice of resumption of the land.
What
My lord has got it, my lord,
you're
page
referring to?
17.
Page?
Page 17, Annexure 1, my lord. Before taking, my lord, through the contentions
Yes.
in the affidavit, I'm just taking, my lord, through the annexures that we have relied on, my lord.
Yes. Resumption.
Yes, my lord. This is the notice. Resumption of government forest land allotted to lessee, allotted on lease to private persons. Whereas some forest land was allotted in past on lease to private persons for the purpose of construction of residential houses or other purposes, as the case may be, the government of Meghalaya is pleased to issue order to the effect that this is very clear, my lord. Number 1, on expiry of the lease, the land will be resumed by the government unless the lease is extended on genuine grounds and that sale or transfer sale or transfer of the land to other persons will not be allowed hereafter. So, firstly, my lord, when is the power of attorney executed? Where is the right of the petitioner? Whether she has the right, you have to have a transferable right to execute any document. Whether there is permission, because it's very clear the terms of even the terms of the lease says that for execution of any document also prior permission has to be sought from the government. So, for executing a power of attorney that you have executed,
Yes.
where is the permission of the government? Firstly, it will be the right, my lord. Secondly, of course, where is the permission of the government? Even assuming that you have a right, though not accepting.
Yes.
Number 2, any structure or investment made during the tenure of lease will be duly compensated, paid for after proper valuation by the competent authorities. So, prior to the expiry of the lease, my lord, this notice regarding the resumption of land, and it says, it is a very fair thing, my lord. It says that whatever investment you have made in the property, that will be compensated. So, for that, obviously, you have to go forward, go to the government, approach the government, they'll do assessment, valuation, etc. Then they will decide on the compensation. So, of course, from this case, it is very clear that the petitioner is never approached, or there is nothing on record to show that anyone has approached for such valuation or seeking such compensation, my lord. Clause 3, there is a caveat, clear caveat, my lord. Anyone buying such forest land on lease will be doing so at their own risk, because forest department will not agree to transfer of the lease or recognize the sale deed. So, my lord, it is very clear that no kind of transfer will be allowed. Even sale deed also will not be recognizable by the forest department. So, this is a clear caveat. So, anyone thereafter, after these conditions being laid down, if anyone is involving in any such kind of sale or execution of power of attorney, it is at their own peril, it is at their own cost. The government cannot be held responsible. And obviously it also expresses a clear bar. In the previous clause itself it says there is a clear bar for any such transfer.
Yes.
Number 4, the Chief Conservator of Forest, Deputy Conservator of Forest must maintain clear records of such forest land given on lease with details of the area when given on lease, expiry date of the lease, location of the land, etc. So my lord, these notice was issued after a clear list was made, and then thereafter on that basis this notice was issued to all the landholders of the short round road protected forest area. Now I'll take my lord to annexure 2, which is at page 18, my lord.
Yes.
Now this is the notice which is issued directly to the party concerned at that relevant point of time, my lord. The petitioner's husband of the petitioner.
Okay.
So there was a general notice of resumption of land.
Yes.
Number 2, there was specific notice issued to the then leaseholders, my lord.
Yes. So this is one of those.
Yes, it is addressed to the husband of the petitioner, my lord.
Yes.
If I may read, my lord. Resumption of forest land allotted on lease to private persons. This is marked. This letter is marked to the petitioner's husband. In pursuance with the above government order, you are hereby informed that the land leased out to you at so and so area of short round forest, wide government order number so and so dated 24/8/1950 will be resumed by the government immediately on expiry of the lease period, that is with effect from the 1st January 89/92, and the lease expires on 31/12/1988. So 1988/1992 will depend on, my lord, when the like there are 2 sections, my lord. One where it is initially granted in 89 with effect from 89 and 92. This is depending on the parties, which parties, my lord. Since the lease will not be extended anymore, my lord has got it.
Yes, yes, yes.
The structures or investment made during the tenure of lease will be duly compensated, paid as per evaluation worked out by this office, and the same may please be seen in the office of the undersigned. You are also required to intimate to this office in writing the names of the persons presently occupying your houses on the leased land and your relationship with these occupants. So this letter is very clear, my lord.
Yes.
Please treat this notice as final, and in the event of your failure to respond, it will be presumed that you have agreed to the government valuation of structures, building, evaluating on the land leased to you, and the same will be resumed by the government after necessary payment of evaluated cost on expiry of the lease period as indicated in the foregoing paragraph. This is very clear, my lord, that the land will be resumed. So once that being so, can there be a question of extension of lease or consideration? Government is considering extending the lease. It cannot. This has attained finality. There cannot be any other doubt thereafter. Then, my lord, I take my lord to annexure 3, page 20. So these are all relevant. So that is why, my lord, I am.
But he speaks of the same thing. Resumption.
Yes, my lord. Now here, my lord, will kindly see. This is a general notice issued to all the leaseholders.
Yeah.
There are also other cases which are, they have all approached this honorable court. There are 4 matters which are analogous matters which are there before this honorable court. So my lord will kindly see annexure 1 to 16. So this is again issued to, so this is not one notice, we should say 3 notices. One, it's a very general notice. Secondly, marked to the petitioner, not the petitioner, the leaseholder at that relevant point of time. And then again to all the leaseholders from serial number 1 to 10 of the list, 1 to 16. So I'm just taking my lord through the letter, my lord. In continuation of to this office letter number so and so above, I am to inform you that the land leased out at Rubban area at Short Round Forest will expire on 31/12/1988. So this is an indication saying that this is going to expire in this year. As per government order above, copy sent to you, wide office letter number so and so cited above, the land will be resumed by the government and no lease will be extended anymore. You are required to make ready for vacating the forest land on compensation of the cost of building as per assessment made by this office within 31/12/1988 positively. So this is the order, my lord. Subsequently, my lord, this order was issued, which they have challenged before this honorable court, and they file a representation, which is page 21, my lord, annexure 4.
Yes.
This is occupant, Short Round Protected Forest. Please verify immediately today and furnish report by tomorrow noon whether currently residing in the plot of land. So a survey was carried out, my lord. This was to verify whether she is residing in the land or not, because that is a statement that she has been in continuous occupation. Now the report is enclosed at annexure 5, my lord, page 22.
Yes.
With reference to the subject and letter mentioned in reference above, I have the honor to inform you that on 11 September 2019 at about 6 p.m. the undersigned along with beat forest officer in charge Short Round Forest beat and staff performed an inquiry at plot number 9 inside the Short Round Protected Forest regarding the occupant of the said plot. The details of the inquiry are as follows. The owner of plot number 9 does not reside in this place, but there are a number of rented houses run by the owner so that itself is not permissible. As per verbal information of one of the tenants, Sri Shiv Shankar Pandit, the owner is not Srimati Devjani Devi, but as per his knowledge, the owner is Srimati Santosh Bajaj. This is some kind of Benami transaction, as I had already informed, appraised the Honorable Court. Resident of Paltan Bazar, Bara Bazar. However, due to ill health, her son, Shri Anil Bajaj, is looking after the rented houses, and his phone number is so and so. The mode of rent payment is by cash collected by Shri Anil Bajaj. The name of the present tenants. So these are the people who are staying, my lord,
Yes.
in the property. Whether that can be allowed, my lord. Obviously, it cannot be. Of all the tenants, Sri Shiv Shankar Pandit is the oldest tenant and has been living in the said plot since about year 2002. On inquiry by your office letter dated so and so, addressed to Srimati Devjani Devi, which has been received by Sri Shiv Shankar Pandit, was informed that the receiver and the said letter was delivered to his owner, Srimati Santosh Bajaj. So ultimately, my lord will see that it is not even the petitioner; it's some kind of a proxy litigation which is going on in the name of the petitioner. Now whether and thereafter these are in the following pages, my lord, annexures. These are all the notices which has been issued to the occupants
Yes.
concerning the Short Round Forest protected area, my lord. So these are the ones. So first and foremost thing, my lord, where is the right of the petitioner? Whether the petitioner has any locus to approach this honorable court. First, she will have to establish her right. Where is her right? Either by title, which is not there. So simply merely by executing a power of attorney, some declaration made in the power of attorney does not make you the rightful owner of the property. You have to have ownership rights, which he does not have.
Yes.
Hmm?
What else?
And of course, my lord, all the rights of the lease holding, everything ended in the year 1988, my lord. 31/12/1988.
Okay.
It's 88, no? Yes. Yes, 1988, my lord. Thereafter, nothing remains. So this is the forest land. It has to be resumed. That is exactly why, and we have been fair. It is like all fairness has been extended, my lord. Prior to the expiry, we have several intimations. I have appraised this honorable court that were sent to all the people concerning that area. That is number one. Number two, you have also been intimated that your lease will expire in 1988 and it will not be extended any further. There was also an offer from the government saying that whatever compensation is to be paid, assessment will be made and then it will be paid to you. So you please kindly come and collect or approach this office within such and such date. So my lord will kindly see where is the locus of the petitioner. The petitioner has not been able to show any locus for approaching this honorable court. Where is the locus? Where is the right? The petitioner has no right. So rightfully this writ petition is not maintainable.
Yes.
At all. And these are all illegal encroachers who are in the land. They deserve to be thrown out. So that is our primary submission, my lord. Now whether they had filed an additional affidavit, my lord, I may just, because on the last occasion while we were hearing this matter, they had, because the question had arisen whether what are the terms and conditions of the power of attorney, etc. Additional affidavit. Now my lord will kindly see. My lord has got the additional affidavit.
Yes. Date?
My lord, this was filed sometime this year. No? This additional affidavit. Bringing on record. Is this the one? Oh, this is the one. Then what is this one? Oh, this is the one. Affidavit filed on record, bring on record the relevant documents in terms of direction. So this was an affidavit which was filed sometime in 30. It says 13th of May 2026.
Yes, yes.
So what is that one then?
This affidavit was filed by this Srimati Santosh Bajaj.
Yes, yes, my lord.
Who is this Santosh Bajaj?
Exactly, my lord. My lord will kindly see whether the petitioner is alive or not. Also, the Devjani Devi, I don't know, that should be verified. Because otherwise she should have signed if that is the case. This affidavit, the petitioner petition is under the name of Devjani Devi. So my lord will kindly page 5, my lord. So what is this? This is another affidavit.
Same thing.
This is the detailed one.
Same thing, sir. This is legal.
My lord, para 5.
Para 5 of?
Apologies, my lord. Page 5, annexure 3.
Yes.
My lord will kindly see where is the power of attorney executed. It is executed at Assam. Is it the same thing?
Same thing, same thing.
My lord has got the page.
Yes, yes.
So, Sri Devjani Devi, wife of so and so, aged about 81 years, permanent resident. My lord, 81 years in. This was in which year? My lord, this was executed.
July 2011.
My lord, this was executed in July 2011. Whether the attorney, whether the person who executed, whether she is alive or not, because if she is not alive, also it becomes redundant anyway. My lord will kindly see. She was 81 in 2011. Whether she is alive in today's date, my lord.
Yes.
That's the first thing that they should clarify. How can this case go on? That
Yes,
itself
who's
should be
appearing?
sufficient to.
Who is appearing for the petitioner? Is he still alive?
My lords, may allow me some time, my lords. I'll bring in the instructions on that.
Because
My
if
lords,
you go
because the
by
affidavit that was filed, additional affidavit that was filed, lordships, recently in the month of May, was filed by the constituted power of attorney holder.
No, power of attorney holder, after
Lordships
expiry,
may-
everything will go.
Lordships may allow me some time, lordships.
If she is
I'll bring
81 in
the instructions.
2011, chances are very less that.
Lordships,
by now,
lordships, I'll bring.
Should be 97 years old.
Huh?
My calculations should be 97 years old.
97 years, touching 100. So that fact, and on that ground itself, the case should go actually.
but you should be abreast of all these matters.
This was because this was filed, bring on record. They recently got it on record.
Lordships.
Because in the last occasion, I had challenged the power of attorney where it was
You
executed.
come back
when-
with your instructions.
Lordships.
You list this matter of the week.
Lordships.
Heard Mr. P. Bhattacharya, GA, state respondent. In course of hearing, the Learned GA has led this court to an affidavit dated 13/5/2026 filed before this court, which affidavit was purportedly filed by one Srimati Santosh Bajaj, said to be the duly constituted attorney of the petitioner. Copy of the executed general power of attorney was also annexed with the affidavit, being Annexure 3 thereof. In the first few lines, it is noticed that the executor, that is Srimati Debajani Devi DEBI, was aged about 81 years at the time when the said document was executed. That is in July 2011. A query has been made as to whether what is the status, what is the
Debjani, which is the lead matter.
as to whether the status as to whether the said executor is still active or not. Miss Learned Counsel for the petitioner has sought for some time to seek instructions in this regard and to inform the court accordingly. Already as prayed for. This is matter of the 1 week.
My petition 153, Lordship, there we already have a sale deed. There's no.
This is precisely the point, my lord. Even sale deed cannot be executed. My lord, we'll see the date of the sale deed.
That is item number 9.
WPC 153 of 2021. Lordship, in this matter, it's not a power of attorney, but a sale deed has been executed.
Exactly, my lord. My lord, I have taken my lord to that order where it
Can you
also
do
bars
that?
any sale deed.
Under the terms and condition of your occupation. Okay, we'll look into it next week.
Lordships are fixing the matter for these limited instructions.
Yes, yes. Because you see, that would be the crux of the matter.
Lordships.
In case the
Anyway, well, it's
we are
even-
not. You see, we are not saying anything.
Well, it's-
We are not passing any. You see,
No, but it's,
any judgment on the petitioner. In case she's still there, fine. You have to
Mileage.
prove her profile. Or
Yeah,
if
otherwise, also, Mileage, she will be having her children. So, in any case, that
But
matter
then
will-
that will also have to be on the court. Then.
That does not.
If she's deceased, let's put it this way: if she's deceased, then
Power of attorney itself will go, my lord.
she has to be
So, if
substituted.
the power of attorney goes, well, it's the right to sue will survive. I don't think the government is going to get a clean slate on that.
But due process has to be
You have to
followed.
have your locus.
We'll have to sort it out.
Please.
Right.
Children will definitely have a locus here.
The lease does not.